3, 2, 1.
Okay guys, welcome once again to another episode of Scott Talks Law. So this is an episode whereby Scott Talks Law, and in this episode we shall be talking about commercial law. So we are going to talk about the contract of the sale of goods. So the contract of the sale of goods, according to section 3 subsection 1 cap 31 of the laws of Kenya, this is the contract that involves the transfer of property in goods from the seller to a buyer in form of money consideration called price. So the keywords there are property in goods, from money consideration, and price. Those are the keywords that you should note. So in the case of Aldridge versus Johnson 1857 case, demands that under this contract of the sale of goods there must be two parties involved. So two parties are involved, and this is the case that involved the transfer of 52 bullocks of wheat with 100 quarters of barley, the difference being payable in cash. So we see that under this contract money is involved, and it involves two parties. So under this contract of the sale of goods, goods has been given a technical meaning. Not everything can amount to goods. Not everything can amount to goods according to this act. Goods has been given a technical meaning, and according to the act, goods involve chattels and chosen action or removable properties. Those are the only things that are included to as goods. So money is not included as goods because the value in money is not tangible. So goods according to the acts are things that are tangible, are movable. Yeah? So the value in money is not movable. So debts are not goods because debts are not tangible. And shares are not goods because shares cannot be touched, they are intangible. So goods has their classification of goods. We have three classification of goods. We have existing goods, future goods, and contingent goods. So existing goods are those goods that exist after the contract has commenced. Future goods are those goods that don't exist during the commencement of the contract. And contingent goods are those goods that are based on particular conditions, sets of conditions. So existing goods has been defined or has been categorized in three different forms. So under existing goods, we have certain goods, unascertained goods, and specific goods. So there are three categories of existing goods: certain, unascertained, and specific goods. So contingent goods, they are based on condition. Farm produce are only available when it will rain. There's that condition that if you want this particular farm produce, it will only be available when it will rain. They are based on particular set of conditions. They are contingent goods. So minerals on earth, these minerals are only available after they are mined. So there are particular conditions that are set for those particular sets of goods. So they are based on particular goods, conditions. They are contingent goods. So under existing goods, you also have this category of unascertained goods. And in the case of Free Weight, a 1927 case, unascertained goods, they are those goods that have not been segregated yet. Like you want 5 kg of sugar that exists in 90 kilogram package. So these 5 kgs of sugars has not been segregated yet, has not been removed from that 90 kilogram package. So this 5 kg is unascertained. So in the case of Free Weight, 1927, unascertained goods are those goods that later become identified as goods to be delivered to the buyer as a result of those goods becoming separated out, and as a result of those goods being separated out. So these are goods that have not been separated yet. So hence no property is passed until the part sold is segregated from the remains of the bulk at least to ensure that there is part sold. The part sold could be easily identifiable. So we see that these goods are not they have not been separated. So that part, that 5 kg has not been identifiable yet. So you need to separate first that 5 kg so that you can identify these as certain goods that can be transferred to the buyer. It's only certain goods that can be transferred to the buyer. So in the case of Morgan versus Russell, a 1909 case, KB 357, the court held that the sale of a slug was not the sale of goods, but the sale of an interest in land. So just under the category of uncertain goods. In the case of Mills versus Stockman, a 1967 case, HCA 15, the sale of a heap of slate which has been left on the ground for many years by acquiring business. Only ascertained just means in this case just trying to bring out that an uncertainty in goods, and it's only certain goods that can be transferred to the buyer. Uncertain goods. The thing that you should note about this contract of the sale of goods, a contract that involves work and material does not amount to a contract of the sale of goods, because that is only the provision of services. It does not amount to the contract of the sale of goods. So in the case of Robinson versus Grave 1935 KB 579, this is the contract that involved a portrait of 250 genius. So appeal held that it was not an agreement for a contract of the sale of goods, but a contract for work and material. The important case is that of Lee versus Griffiths and 1861 that involves the transfer of dentures by a dentist. So a contract that involves work and